So the federal law which prohibits nonviolent felons from possessing firearms is once again under review after the Supreme Court's recent 8-1 decision in GVR, and our side just got a hard break. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Kershaw Knives. Kershaw has amazing knives. They support the channel and they've been supporting the channel for a long time. I carry their Kershaw Iridium knife every single day for my EDC. So if you just want a quality knife and you don't want something that breaks the bank, check out Kershaw Knives. And if you use the code ARMED40, you can get 40% off of your order. Now, as I mentioned in the intro, in this video, we will be discussing a huge Second Amendment case that the Supreme Court recently GVR'd, which means they granted, vacated, and remanded after their 8-1 decision in Rahimi. The case we're going to be discussing is called Range versus Garland, and it involves a challenge to federal laws which essentially prohibit someone with a nonviolent felony from being able to own, possess, or acquire firearms. This case has become even more important in light of that 8-1 decision in Rahimi, and now this case is once again back in the hands of the Third Circuit en banc panel, who has set an argument in this case. The Third Circuit currently set this case to be argued in front of them in light of Rahimi, and it's set to be heard on October 9th. And then they issued an order making the arguments even harder for our Pro 2A side. Now, for those not aware, the Range case involves the issue of an individual losing his 2A rights under a federal law essentially forever. 26 years ago, Mr. Brian Range was convicted of concealing some of his income so that he could obtain additional food stamps for his family. And because of that, he was charged and convicted of a Class 1 misdemeanor in Pennsylvania. Mr. Range has had no serious criminal issues before that or after, but it's just simply that one time lying about his income to obtain food stamps that has now lost him his 2A rights forever. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General, the ATF, and the Biden administration seeking declaratory and injunctive relief. The district court ruled in favor of the federal government on their motion for summary judgment, which means that they ruled early in favor of the federal government. After losing at the district court level, Mr. Range appealed up to the Third Circuit. On review, the 3-judge panel in the Third Circuit issued an opinion upholding that lower court decision, but they sided and used Bruen. The 3-judge panel cited history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding responsible citizens. So their primary finding was that Mr. Range, because of that conviction, was not one of the people as mentioned in the Second Amendment. Now, Mr. Range didn't quit there. He then appealed up to the en banc panel in the Third Circuit. And on review, the Third Circuit en banc panel ruled in favor of Mr. Range. The primary finding of the Third Circuit en banc panel was that all the lower courts were wrong. Mr. Range is one of the people despite that conviction. In their ruling, the Third Circuit en banc panel stated that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people entitled to keep and bear arms and that our nation has no historical tradition of disarming people like him. The government responds that Range has not been one of the people since 1995, when he pled guilty in Pennsylvania State Court to making a false statement on his food stamp application, and that his disarmament is historically supported. And on review, the Third Circuit en banc panel found in favor of Mr. Range, finding that yes, this aspect of federal law is a violation of the Second Amendment. That essentially then led to the federal government here to then seek Supreme Court review. They filed a writ of cert to the United States Supreme Court. Now, here's where things got interesting for the Range case, because there was another case that we've talked about, the Rahimi case, that was also up for Supreme Court review, dealing with a similar issue about who is among the people, what aspects of federal law may be unconstitutional because they strip people of their right to keep and bear arms. And that was the Rahimi case. The Rahimi case was granted review by the Supreme Court, and as a result, the Range case was then put on hold behind Rahimi. And as many of you are aware, the Supreme Court recently issued their decision, an 8-1 ruling in the Rahimi case, and they found that that section of federal law was in fact constitutional. So they ruled in favor of the federal government, but it was a little bit limited in its scope. The analysis was aligning with Bruen. There was some unfortunate language that some lower courts, some circuit courts are going to latch onto to try to expand the definition of Bruen. But what ended up happening is this Range case was then granted, vacated, and remanded back down to the Third Circuit for a new analysis, a new decision in light of Rahimi. Recently, the Third Circuit en banc panel opened the case back up. New arguments were submitted to the Third Circuit en banc panel in light of Rahimi. And in the first briefs, Mr. Range argues that the rationale in Rahimi really should not change the outcome of the decision that was issued prior at all. Mainly, he tries to draw a distinction between the type of temporary disarmament that was involved in Rahimi versus the more permanent forever ban that is involved in Mr. Range's case. Now, one of the other important things that they point out is even after Rahimi, and one of the good things about Rahimi is there was this rejection about the responsible person analysis and the responsible person argument that was brought not just in Rahimi, but also in this Range case. The Supreme Court rejected that type of rationale. The Third Circuit en banc panel on original review in this Range case rejected that analysis, and they should just reject it once again because of that Rahimi decision. Now, recently, the Third Circuit en banc panel issued an order setting oral arguments to take place in the Range case on Wednesday, October 9th. However, here is where things are a little bit complicated for this case. In response to that, the attorneys for Mr. Range filed an unopposed motion to the Third Circuit en banc panel asking for the argument date to be moved potentially earlier or probably later so that they had additional time. The unopposed motion notified the Third Circuit that the attorneys here for Mr. Range are also the attorneys in the Vanderstock versus Garland lawsuit. That deals with the ATS rule on unfinished frames and receivers, essentially their 80% restrictions that's currently set to be argued in front of the United States Supreme Court. And the Vanderstock case is set to be argued in front of the Supreme Court on October 8th. So that's just one day, just the day before the Range arguments that are currently set. The counsel for Mr. Range simply asked for the Third Circuit en banc panel to move those arguments, and also the government's attorneys here did not oppose that. They did not oppose moving the dates. Mr. Range's attorneys acknowledged that the en banc panel's arguments, to be moved are very rare. There has to be significant hardships. However, the attorneys here for Mr. Range argue that, of course, having to argue a day before that, the Vanderstock case in front of the Supreme Court, and then the very next day go to the Third Circuit en banc panel and argue this case is pretty hard, it's pretty difficult, and a lot of times these types of arguments will be shifted based on the attorney's schedules. However, what is interesting here is we got an order from the Third Circuit en banc panel, and they denied that unopposed motion. So they are not going to move the argument dates. So the Pro 2A side will face an uphill battle going forward during these next round of arguments. They will have to now run kind of the gambit of arguing the Vanderstock ATF lawsuit in front of the United States Supreme Court on October 8th. And then they're going to have to run over to the Third Circuit en banc panel the very next morning and argue the Range case in front of that panel. Now, I definitely don't envy those attorneys, but the Third Circuit en banc panel did not want to move those argument dates. The one thing I will say about all this is that there may be a potential silver lining with this, because keep in mind, the en banc panel in the Third Circuit already ruled in our favor once before in the Range case. I don't think the Rahimi decision is going to change their analysis much. If anything, I think they will potentially just rule the same way, reject a lot of the same arguments that they rejected before, but have authority, like the Supreme Court saying the responsible person analysis is not proper in light of Rahimi. So it could be one of those situations where the en banc panel in the Third Circuit knows that they're potentially going to rule the same way. They don't want to delay the arguments anymore. They don't think that it's going to be hard enough for the attorneys to argue both cases on the different days. So they're just simply going to try to streamline this and potentially issue that hearing as soon as possible, issue a quick decision, and inevitably move this towards a quick Supreme Court cert, maybe even during this very term. That would be best case scenario, so maybe that's what the Third Circuit is thinking. So that's what's going on in the Range versus Garland case after the Supreme Court's GVR. It is now set to be argued in front of the Third Circuit en banc panel on October 9th, and we're going to be looking forward to that week because there's now going to be a lot going on in the 2A side of litigation during that week of October. And if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.